First of all, you don't let the commercial environment within which you find yourself cloud your judgment. When the economy is in a downturn, as it is now, and as it was then, engineers often find themselves in a situation where they are extremely, thankful if a client comes to their door and wants to appoint them. And they let their judgment go out the back door as they do what they can to ensure that they get the work. And what that means is that an agreement is entered into which isn't fair and it isn't equitable and it's problematic from the start. The following important considerations, I believe, apply before you contract. We heard about the JBCC, we've heard about other contracts, but the most important contract from your point of view is what is your professional contract and how does it work? First of all, before you contract, understand your client. Nobody's business is about. And secondly, hugely important, establish whether he is financially sound. Because if you start your contract by contracting with a man of straw, you're in trouble before you start. Next question, is the client an informed client? Does he understand what the service is that he requires you to render? Because it makes a huge difference. If he's informed, you and he can be on a par and you can reach agreement easily. If he's not informed, he must be informed about what he's embarking upon. And lots of clients embark upon projects which they shouldn't embark upon. And that's where engineers also get themselves into trouble. And then the most important, is he amenable to entering an equitable or fair agreement where risk is evenly spread? In this case in point, in my war story that I've told you about, that wasn't the case. The client was in a strong bargaining position due to the commercial landscape out there and the fact that engineers were hungry for work at that stage. And the consultant entered into an extremely one-sided agreement. At that stage, there was still the old CESA agreement that was used in the engineering fraternity. And the engineer, I think, was under the impression that the CESA agreement applied. But what he didn't look at was a very detailed letter of appointment containing extremely onerous conditions, which in a sense overrode the CESA agreement. What it said is that where there's a difference between the letter of appointment and the CESA agreement, the letter of appointment will be the governing document. And there was this one little clause in the letter of appointment. Now I'm going to read it carefully and just think about this. One of the obligations that the engineer assumed was to ensure, listen to that word, ensure, that the quality of the works complies with the relevant structural specifications and drawings in all respects and is consistent with good building practice. So what you're doing by signing or by allowing yourself to contract with this letter of appointment is that you will ensure that what the contractor does is 100%, literally. At the same time, the client refused to contract for a full service and insisted that the consulting engineer cut their fees to the bone, which they did. And they also refused to allow for full-time site supervision or monitoring, as it is now called. So the engineer was out on a limb, he did his design, and when it came to monitoring, the client in this case, or the developer, said, listen, I know that you want to spend more time. I'm not going to pay you on a time and cost basis. You are going to monitor. That was your undertaking. And it's whether it takes you a lot of time or a little time, it's not my problem. The client then also went and appointed the cheapest specialist structural steel contractor to do the structural steel work. And this contractor was sadly financially constrained from the outset, and in the project he eventually ended up cutting corners. He appointed welders who were not properly qualified, and as I said, the welds were a huge problem, and that was a disaster. We were also mentioned that tests that were called for weren't allowed. At a stage, the design engineer was extremely concerned and saw danger signs concerning the quality of the welding. This was a particularly important girder, and eventually he said he recommended in writing to the employer a load test. He said, I haven't been able to climb up on a cherry picker and check over the over the shoulder of the specialist steel contractor, whether these welders are doing full penetration welds. I am concerned and I want a load test to be done. The answer from the engineer, at least from the employer, was the following. Who's going to pay for it? And we don't have the time, because we've got to open on the 10th of December, or whatever the date was. The sad bit is that if the engineer had stood his ground there and written to the guy and said, listen, we're downing tools, or we're not going to give you an occupation certificate, or whatever, that disaster wouldn't have happened. So a catastrophic collapse could have been avoided if the engineer had stood his ground under those circumstances. And it's very easy for me to stand here with hindsight, which is 20/20 vision, and say that should have happened. It's not easy in practice, as you know. You must ensure that the agreement you enter protects you adequately. You must utilize a standard form of agreement, and you must avoid bespoke agreements. Now, bespoke agreements is a fancy word for agreements drawn by the client, to which you don't understand quite what was in his mind when he drew these papers. Am I right about that? And if you are confronted with a bespoke agreement, and a client insists that such an agreement be entered into, please, at that stage, take legal advice and ask somebody who's a specialist on that type of contracting to look at it for you. Here's a punt for CESA. The CESA Model Services Agreement is a fair agreement, and it balances the risk between engineer and client. It provides the following. First of all, there's the common law requirement that an engineer must comply with. It says the consulting engineer shall exercise reasonable professional skill, care and diligence in the performance of the services. It restates the common law, and the word reasonable is there. You don't have to deliver your services, the services don't have to be of an exceptional nature. If they are reasonable, then you have discharged your responsibilities. The other aspect which is hugely important is that the agreement, in my view, must address the issue of remuneration. Now, the CESA agreement addresses that adequately. And I would like to stress the following. Appropriate remuneration, or enough money, is the key. So and you need to understand that. You can't render services if you are being inadequately remunerated. To do that, you must understand what the scope of your services are, and you must do a proper costing so that you're not caught short. A lot of engineers think that, you know, they'll tender low and then they get the project, and hopefully then they can make up with a bit of extra time. I can tell you what happens in practice. The client says to him, when the first time he comes and applies for a time and cost appointment on some other aspect, the client will say, go and read your contract. And off he goes with his tail between his legs, and he's involved in a very debilitating, expensive contract where he's not making money. The other thing is that you need to insist that the employer makes payment of your invoices timeously. Now, engineers are decent people, but they are extremely naive, and that I say, as lawyers always say, with respect. And engineers believe that they will, to use the word, they will piss their client off if they're going to ask him for payment in terms of the timelines. Now, this is also a recipe for disaster, because if you allow the employer to fall in arrears, you are in big trouble. Section 217 of the Constitution of our country and the Public Finance Management Act governs the procurement of goods and services by an organ of state. Now, bear in mind, there's the Public Finance Management Act, and there's Section 38 of the Act, which provides the following: that the accounting officer of a state department must settle all contractual obligations and pay all money owing, including intergovernment claims, within the prescribed agreed period. Now, that, in terms of that act, that is what the government department or the organ of state that you contract with is required to do. So in future, if they tell you that you must wait for your money, go and refer them to Section 38 of the Public Finance Management Act. There's also in the Municipal Finance Management Act, there's a similar provision. Despite this obligation on government departments, in my experience, they are inclined to delay payments, and consultants often end up litigating against their client. Engineers are under the impression that, wrongly so, that You know, first of all, the contractor who's done the shoddy work is the first line for the client. And this isn't so, because the clients have two contracts. They have a contract with the contractor and they have a contract with the engineer. And the clients are entitled to choose their victim, as it were. And mostly their victim these days is the engineer, because of the nice PI cover that the engineer enjoys. So consider that clause in contracting. Some general observations. Where engineers have got into trouble and landed up on the wrong side of the law is in cases where they've bitten off more than they can chew, where they've been unclear about the terms of their appointment and their contractual responsibilities, where they believed in the bona fides of their client, where they believe this chap who's got this open, shiny face on the other side of the table and who shakes your hand and pats you on the shoulder is going to always have that approach. That isn't the case. And then mostly, and very importantly, they've trusted implicitly what contractors tell them and failed to check that the contractors had a proper quality assurance plan in place. This comes down to supervision. And this is where most of the claims against engineers come from. People can design, but supervision is a huge problem. And if you trust a contractor, you're in trouble. Further observations. You must act on your instincts. If you have a nagging feeling that something is not right, you can be sure that it's wrong. Trust your gut. You must hold the scales fairly between your client and the contractor, and you must rule fearlessly. You must take advice from your peers, but mostly from your lawyers. That's tongue-in-cheek. And then the other important thing, you must get up to speed on how PI insurance works, and you must utilize the services of good specialist PI broker. Ensure your contract with your insurance company is just as important as your contract with your client. And insurance companies are also having difficulties with their bottom lines, and more cases there are where insurance companies repudiate because the claim wasn't notified properly, etc., etc. So those are the difficulties that you face. I always say you must be close to your professional indemnity insurer so that you can be sure that he doesn't remove that big yellow umbrella when it starts raining. There's still a lot that I can talk about regarding arbitration, litigation, and how all this happens. But if your contract is in place and your contract provides for, in the first place, a dispute resolution process which entails an amicable settlement discussion followed by mediation, followed by adjudication, and followed by arbitration. It can be a lengthy process, but you will be able to get there. Mediation is something that people in South Africa don't understand. It's a concept that I think is hugely important. It's something that I believe can resolve issues. But mediation can only work when there are two willing parties who wish to resolve a dispute, as is the case with arbitration. The most difficult thing in the world is to arbitrate against a guy who doesn't want to arbitrate, who doesn't want to pay you, and he is raising spurious defenses for paying you, and you have to drag him into an arbitration. That's a disaster. That, ladies and gentlemen, is my story. I just want to get back to what the professor said. The Japanese model is a brilliant model where you can walk in and you can shake a hand and you know this is your agreement. You can also then know that if there are two parties who are in an equitable relationship and are both in positions of strength when they negotiate, not bargain, then you can reach an equitable agreement. And you can then, if you have reached such an agreement, you can actually chuck it into the bottom of the cupboard, get on with your work, and you will come out smiling on the other side. Thank you very much.
All of this that I'm telling you is not to give the lawyers work, it's to avoid disputes. And if we avoid disputes, we all sleep better. We don't have sleepless nights because to resolve disputes means you've got to go and work after hours because your normal work carries on regardless. So we need to make sure that we understand things and we don't get into trouble. And believe me, our lawyer friends are not going to starve. There are enough things that will still go wrong. So we need to communicate, we need to make sure that we've got a competent design. We know that our requirements are enforceable because we've specified them correctly. And if necessary, fairly early on, that if there's a problem, we've said so. If the contractor doesn't have information, or if he can't solve something, or he doesn't know how to solve it, please put up your hand and say, how do I do this? Don't just carry on regardless and hope it's going to be the right sort of thing. Then the other thing that my quantity surveyor friends like to do is that you leave all the claims right to the end, because then you can go and do some horse trading, which is not the same as bargaining or negotiation that the professor spoke about. Please, if there's a problem, let's go and solve it. If this thing has gone wrong, let's go and see what has gone wrong. Everybody's around, you can see, you don't have to dig it up or scratch or plaster. If the contractor's owed money, then he needs to be paid. If the contractor's entitled to extra time, then he must be given time. If the contractor's got it wrong, then he's got to fix it, but that's it. But if you leave that until a year later, at the final account stage, you've got no idea what happened, you can't go back on the records, you can't go and see things on a building site. Then very important, things now go wrong. How do you define these things? Please, doesn't matter which form of contract you use, doesn't matter what they are, they all have words that need to be used. The favorite one in our case is we have contract instructions, we don't have variations in the JVCC. We don't have a snag list, but we have a defects list. So if as a contractor you now submit a claim in terms of the JVCC to say the variations as a result of whatever, the arbitrator, adjudicator, whoever is going to look at it and say, but there are no variations in this agreement. What's your problem? So if you are dealing with any form of claim, please follow whatever that form of contract says. Make sure the information is correct and up to date. Tendering. Why do we tender? Basically to get the most effective price. And that is a quotation from an English judge, believe it or not, was the name of Ian Cookie. A prudent owner would also consider the capability and experience of the contractor and how realistic the tender price was. Very important wording. The four agreements that we use generally all have the same sort of wording, but the employer does not necessarily guarantee that he'll carry on with that project. To go to tender is an expensive exercise for the employer. You wouldn't do this lightly if you didn't have the intentions to carry on with the project, but circumstances may change. You might have lost a major tenant. There could be political upheavals. You also don't necessarily agree to accept the highest, lowest or any other tender or give reasons for that, which has fortunately been upheld by the courts a couple of times. So these are very important criteria that you need to follow. Then the CIDB definition of preferential procurement says award tenders in accordance with a system that is fair, equitable, transparent, competitive and cost effective. It doesn't say anywhere the contractor's got to be competent. And that's really what we need to have, is competent contractors at the right price. And they're around. We have spoken at length to CIDB and Public Works to go and follow the Swiss system. And the Swiss system is that you go and invite everybody you want to go and tender for the works. You obviously have to go and sort them out, and you'll find that a fair number don't qualify. And of those who do qualify, let's say you get down to the last 8 or 10, you take the average of those 10 prices and see who's closest to that price. And chances are that that is the lowest realistic price. Because if you take a totally realistic example, some poor quantity surveyor in the contractor's office drifts into the boss's office at 10 o'clock and says the price for this job is 9,876,543 rands and 21 cents. And the boss, who should know better, says, okay, so who else is tendering? If we get it, who's going to do it? How desperately do we need the work? We do need the work desperately. Okay, well in that case maybe we should go in at 9,5, 6, 7, whatever. So you've left $500,000 off what the quantity surveyor has worked out is what this costs. So you now go and submit your price at 9,5 whatever million, and the next lowest price is 10,5 million. So what are you going to do? Put more water into the paint, use a little bit less cement, try and get away with second-hand tiles. Standards I've referred to, there are lots of them. Find the ones that make sense for your product. Is that off-shutter concrete? Well, yes, it is off-shutter, but it's not the sort of finish one intended. If you see steel that is marked like that, that can be good news or bad news. And that is part of the problem with the power stations. That sort of steel is brittle and is unique in terms of its handling and welding facilities.
I'm joined here by the Managing Director of Weavand & Weavand Attorneys, Mr. Rayford Johnson. Rayford, thank you so much for joining us.
Actually, nice meeting you and nice talking to you.
Fantastic. So I would like to start off by asking you, how often does it happen that one misreads their contract in the engineering industry?
Every day. It's something, the contracts are unfortunately very involved, and engineers, as one of the previous speakers said, read the first 10 pages and then from there it becomes difficult. And what they should strive for is to get a contract that isn't complex, and then they should read it regularly, and they shouldn't chuck it into the bottom of the cupboard. They should read it not on a daily basis, but they must read it regularly. They must know what it says.
And just to follow up on that one, what can they do to make sure that the contract that they're about to enter into protects them?
First of all, they must go to one of the standard model contracts in the industry, like the CESA agreement. You also get the FIDIC model client agreement. Those are important agreements that have been thought through by engineers for engineers. And if there's still uncertainty, you can consult your lawyer.
And lastly, how has your experience been so far as a speaker at this year's Imbizo conference?
I think it's been very exciting. It's wonderful to see the young faces and the enthusiasm that I see around this Imbizo, and it bodes well for the future of our country and for the future of the industry.
That's absolutely fantastic. Thank you so much for joining us, Rayford.
Thank you.
I'm joined here by the CEO of Joint Building Contracts Committee, Mr. Uwe Putlitz. Uwe, thanks so much for joining us.
Hi there. What can I tell you?
Well, what I would like to ask you is, how important is it to know what you're getting into, especially with the other parties when it comes to a contract?
Well, this is where you need to go and have a whole lot of information long before you get near a contract. As the employer or the client, you've got to decide what this project is all about. So you've got to have a fairly detailed brief to say, this is a project, that's the amount of money, that's the time I want it in. Those are the consultants I need to do the work. They need to get paid fees to do the job properly. And then you can go out to tender. And based on that, you would then hopefully select a competent contractor to go and do the work within that tender amount of money to the quality that you specified within the time that you specified.
And should one reach a dispute with the parties involved in the contract, what appropriate steps can be taken to make sure that the dispute is resolved?
Well, assuming there's one of those sort of contracts where the consultants work for the employer, they're obliged to go and see what the contractor is doing is in accordance with the specifications, drawings, etc. So as the job progresses, you need to go and monitor the progress, and if it's not what it should be, that you go and say, hang on, what's the problem? Have we not given you the right information, or are you just not competent to do it, or whatever the reasons may be? And then you might have to decide, do I go to the extreme step and fire the contractor, or is it something that we can do by accelerating the work, and that costs money? Or maybe there's an extra instruction, there's maybe more work that the employer might have asked for, in which case the contractor will need more time and more money to do that work. So it depends on those circumstances.
And lastly, I would like to find out from you, how has your experience been thus far at the YPF Imbizo conference?
Oh, I think it's been very good. The opening speech was fantastic, and the enthusiasm of the audience is great. And it speaks well for the future of our country to have so many young engineers so enthusiastic.
All right. Thank you so much for joining us once again, Uwe.
My pleasure. Thank you.